Surely, you will have to say it.
No.
Do you understand this? It spoils the image of the lawyer. Once you do this, for whole career, you have spoiled your. No, we will not believe you whenever you will come with the case and say anything, because we believe the lawyers. We do not turn the pages and see whatever the lawyers say. We accept it, believe it at the first hand that he must be correct. Now, if you do this, that in a bunch of petitions, one of them is not maintainable, and you just try to push it up, and that is not fair on your part. Sorry will not do. Mahendra may also not have seen it. It is all similar matters.
Yes,
We also believe it to be similar matters.
There is a mistake on my part also. I apologize. I have not seen it.
This is not fair. Not expected from a lawyer who is an officer of the court. What do you have to say on this? You decide.
May I make a submission? In all these cases, a submission was made on in all these cases that there was no provision for applying online at all. Your Lord may kindly see, in this case, they only produced the online application. They applied. They are avoiding to apply online? Because they have to fulfill all these conditions mentioned in the, they have to declare. Your Lord may kindly see, page number 39. There are several conditions to be fulfilled, as many as 13. 13 declaration they have to make. In order to avoid that law, they are making physical applications.
File your objections, Mr. Man.
Please.
We'll deal with it so that future matters are dealt with properly.
Please, I'll file it.
This application is filed at the instance of authority because they themselves decided to file this application. First of all, this application.
Surely, please don't press it now. Let him file his objection. We'll consider it after the objection. There's no order that we are going to pass today. Then why are you making a submission?
Because Learned friend, he is appearing in several matter. Every time he is coming with a different submission. He is misleading the court. He is not fair to the court because he has appeared in several matters.
Surely, it has been established in this matter that you have not been fair. So please don't make these kind of submissions. Let him file his objection and we'll consider it.
On the other
Please restrain yourself and don't do all this.
He also should be fair to the court because I may be part. It may be part on my part because I should be.
All that I have pointed out.
We'll consider the fairness. Please don't get into this. Otherwise, we'll have to make observation in this matter.
Because on the other day,
you want us to make an observation in this matter, Mr. Shivali?
He simply considered. That is the reason why I gone away.
Okay, we'll make observations.
Sorry, Lord.
Please don't push us.
Every time he only starts making submission, that should not be the attitude. He should be allowed to petition first to make submission. That's not my submission.
Okay, we'll pass orders.
Let him find out.
Please restrain yourself. Don't do this. This is not.
Sorry, Lord.
Dismiss the petition. Will not permit this thing to happen in the court. Sorry, Mr.
Not in this case. The issue has.
My brother has been lenient to you. I was not saying anything, but you are not realizing your mistake also.
Now, fairly, I'm admitting.
So now we will dismiss your petition regarding all this.
I'm fairly admitting that there was a mistake on my part. I do admit, but this is a settled issue, Lord. Issue has been settled. But this court in category various pattern of judgment. with all this, not that he only made submission.
Why you said that this is a similar matter? Why you said this? First explain. Why didn't you point out that this is not a similar matter and this is a separate matter which is covered by some other matter?
Apology, not.
No, no apologies. Your client has to suffer because of your misconduct. And if you want, we can record this thing, your misconduct, and send the matter to the Bar Council. What do you feel? That the court cannot do that? You are not realizing your mistake. We have been pointing out to you. You are you're raising your voice. You are trying to tell that the counsel for respondent is wrong.
I'm sorry, I will not make it.
We'll dismiss your petition and refer the matter to the Bar Council. Take out.
Asif's kindly.
What is going on? Realize what they have done is not at all approvable. And in spite of, we have fixed this matter today. What for? To grant you interim order. I leave it to my brother. I don't want to spoil my mood in the morning itself. You do whatever you feel.
We don't do this again, Mr. Shirley. We'll dismiss this petition. We are refraining from reference to the Bar Council, though it requires it to be. The matter has come up for hearing on.
Letting file objection. Kindly report it.
Now, if you insist on it, then we'll have to. The matter had come up for hearing on 22/2/2022. Learned counsel for the petitioner, who had filed 8 other matters on that day, had made a submission that this matter and the other 8 matters are similarly situated and are covered by a decision in WP number. WP number 18368 of 2021, and requested for similar orders to be passed. Shri S.S. Mahendra, learned AGA, under the bona fide belief that they are also, all the matters are similar, consented to the said orders being passed. When the matter was, when the order was,
The time of signing.
at the time of signing the order and on perusal of the petition, it was found that the present petition is grossly different from the other 8 matters, inasmuch as the application filed in the present matter had been rejected on account of the same not falling within the same safe zone, which aspect had not even been brought to the notice of this court. The relief sought for are also different, inasmuch as in the present matter there is a certiorari also sought for, whereas in the other matter there was no certiorari sought for. In view of the above, we are of the considered opinion that there is a gross abuse of the process of court, disentitling the petitioner from any consideration, equitable or otherwise. Though other serious action could also be taken, we refrain from doing so. The petition stands dismissed on account of the wrong submissions which had been made, misleading of the court, as also the abuse of the process of the court.
To Jairam K.
For the appellant, Your Lordship, there is another related matter, Your Lordship. In COMAP number 6 of 2022, as between the same parties as arising out of the same contract, Your Lordship. And that matter, Your Lordship, has been ordered to be posted before a different bench. And this matter is also to be taken along with the same matter, Your Lordship. Connected matter is COMAP number 6 of 2022, Your Lordship.
COMAP 6 of 22.
22, Your Lordship. That has been ordered to be placed before a different bench when it came up before the Honorable Court on 14/2/2022.
Once we connected.
To be called along with the same matter.
Learned counsel for the petitioner submit that the above matter is connected to COMAP 6 of 2022.
Please.
When is that listed, Mr. Rajaram?
It's not listed, Your Lordship. It has been ordered to be placed before a different bench.
Directed to connect this matter with the said matter and list on the date on which the said matter is listed.
Please, Your Lordship.
Number 3.
My lord, I appear for petitioner, my lord. My lord, the petition, my lord, is not in order. It is not in conformity with Rule 18, my lord. Rule 14 of 18, and also there are some latest developments. In that regard, my lord, I have filed a memo for withdrawal of this petition, my lord, with liberty to file, my lord, the comprehensive petition on the same grounds, my lord.
You have to withdraw.
He wants to withdraw and file it.
The counsel for the petitioner makes a statement at the bar that he wants to withdraw the writ petition with liberty to file afresh. You want to file afresh?
Please, my lord. Please, my lord. Your lordship may give me liberty.
In this regard has been filed, which is on record. In view of above, the writ petition is dismissed as withdrawn with the force of liberty.
Liberty, my lord. I pray for a liberty.
We have given you liberty.
Please, my lord. Highly obliged.
Number 4. AMV Charity.
For the appellant, I sought for a dispensation. Translation document. Lord, I shall undertake, Lord, that I will produce the translated copy within 3 weeks. But the urgency why I have moved is because the respondent has moved the contempt petition. Lord, wherein, Lord, the learned single judge has extended the time under Rule 13. Lord,
Have you removed the objections?
Office objection, other office objections are removed.
All
except-
office
Yes,
objections.
Lord, except translation.
Nothing can be done. If you want matter to be taken up, then you will have to remove the office objection.
Next time, Lord, Lordship may have it on next Wednesday or Thursday, Lord, by then I would have produced the translated copy.
Under counsel for petitioner, as far as allowed, a week's time. So remove the office objections. Keep it there.
Number 5. Government. Time for the respondent. It's in this notes. I've received the entire set of paper by my learned friend. But yesterday they have also filed an additional application for production of certain additional documents. So I would request Malas to grant me a week's time. I'll file objections to the petition as well as the applications as well. Please, Malas.
Whether notices have been issued?
Yes, notice has been issued.
Okay, sir. On delay.
When the notice was issued? When it has notice, when notices have been issued to respondents. See whether notice has been issued because it's a review petition.
Yes.
Yes.
There is a delay of 59 days. In my delay.
You see from the order sheet, the notice has been issued. Just send the notice, but order sheet does not say so. Thir- 30th August 2019 notice was issued. What do you want?
Seeking time. I filed an application on 23rd February 2022, not seeking to produce certain documents.
A review petition.
Not that this document was referred in the order. Not the document was referred directly.
All right, you filed objections.
Please.
Whatever you want.
Grant me a week's time, or I'll file it by then.
Adjourn on the request of counsel for the respondent. Just after 1 week.
Okay. 9th March. Number 6. Maybe Paula.
As per the Sound Court order dated 12/1/2022, the award copy received date on 28/8/2019. Same is produced the certified copy of grade file along with memo.
When did you file the 34 petition, Mr. Counsel?
It is filed on 30/11/2019.
30/11?
2019. 30/11/2019.
What is the limitation period? Arbitration.
The lower court has that it has to be filed within 90 days. After 30 days, it can be considered. But the lower court has that it is taken on 23/7/2019 as the order date, received copy. Then my arbitration, the application is rejected, my lord, on the ground of delay of 37 days.
From the date of the original award.
Yes, my lord.
Your contention is you received it on 28/8/2019.
Yes, my lord. I
So if
produced
it is
memo.
on 28/8 is taken, what is the delay? Is there a delay?
I don't have any that I produced in the same lower court in the plaint I stated, and
What is the date of the award?
our date is 23/7/2019.
7/18/19.
19. Yes, my lord.
If 23/7 is taken, there is a 37-day delay.
Yes, my lord.
Even then, there is a delay of 3 days.
Yes, my lord. It can be extended as per the section 34 subclass 3. It can be extended up to 30 days, my lord, after lapse of 90 days. In page number 15.
For the period of 30 days. 3, 90 days, 30 days.
I have only the documents to show that plaint I stated in the lower court. I received the arbitral award 28/8/2019, my lord.
Is there any evidence to show that?
My lord. Yes.
Is there any evidence to show that you received it only on 28th?
Except that no documents or evidence I don't have. I have
How can
only
we
one-
believe this without any? That is why you were asked to submit the documentary evidence
that,
that of the date of service of arbitral award.
I don't have only that plaint and in the
Finally,
IA
the
also I
document
stated.
award on the
It is there, then we can do it. If he doesn't produce it, we can't.
They cannot do it.
And the award date itself 23/7/2019. Same day it cannot be received, my lord.
Mr. Balan, there is no question of condemnation of delay in these matters.
Yes, ma'am.
120 days, that's it.
Yes, ma'am.
If it is 120 days, you are 7 days delayed.
Yes, ma'am.
Unless you produce some document to show that it was received within 120, your filing is within 120 days of the receipt, you can't do anything.
Look, in this regard,
Section 5 does not apply. So unless you produce, we can't help
We
you.
cannot go against the statute. How can we condone the delay?
in the delay applications also stated, but I don't have documents. I applied for an RTA before the arbitrator. When I award received,
RTA will not
that
be
document I not yet received, my lord. The RTA I filed application when I award received. That documents not yet received. I filed a RTA application before the.
How did you receive this award?
RTA.
There must be some proof from postal track record or something you could produce. If you are not producing, we can't help you.
Kindly grant 2 weeks time. I will get that RTA.
Yes, time to be had
Twice
granted
it's
you.
been given. Mr.
My lord.
Twice time has been given.
Oh, we will not give you time. Sorry.
RTA application I filed when I received it, but that documents they are not yet produced by the arbitrator office. I have only plain which is filed before the lower court stating that I received the order copy on 28/8/2019.
If you have only that, we can't help you, Mr. Balan. That's the
Kindly
problem.
grant me 2 weeks time. I will get that RPID tracking record or any other documents.
Twice already time has been granted.
My lord, it is in Dakshin Kannada. I could not get the documents. They also filed the RTA application when the award copy received. That documents, they are not yet furnished to the arbitrator office. The documents are at the application I have.
Because it's land acquisition matter. But please find out and produce it, otherwise we'll have to dismiss. And counsel for it. Appellant seeks for and is granted 3 weeks time to produce any document evidencing. 2 weeks. 2 weeks. No more. 2 weeks and no more to produce a document evidencing the date of service of the arbitral award on the appellant. If no such document is produced on the next date, the petition will be liable to be dismissed on account of the delay in filing the Section 34 application.
21-3. Number 7. My suit is visited.
This is not
One of us tried the name of the other is not a member of any necessary nomination. Let me set aside from the on the list.
Number 8. Sanjay BK. Sanjay BK.
I appear for the petitioner, my lord. I appear for the petitioner, my lord.
Yes.
Please, my lord. This is a review petition.
Yes.
Please, my lord. This is a review petition filed being aggrieved by the orders passed by this honorable court on 18/1/2022, my lord. The fact is that the objections prepared by the state, whether on 10/3/2020, my lord, which is at paragraph at page 41, or the statement of objections prepared by the state on 31/12/21, on page 20 on 62, my lord, has not been filed before this honorable court. I have been able to obtain the copies through through RTI, my lord, and unfortunately, none of these came to be filed before this honorable court. On 18/1/2022, when this matter was called before this honorable court, the entire office was down with Omicron, my lord. The junior advocate appeared and sought for time. However, the same was not noted by this honorable court, my lord. A public interest litigation came to be filed in writ petition number 53062 of 2019, my lord. Now, the petitioners are none other than my competitors who became my adversaries, my lord. Constantly, they lodged a tirade against me, trying to pull me down, my lord. Their only gross was when there was MOU entered between the state and me, my company did not exist, my lord. The tender, the requirements of the tender was not that I had to be a private limited company, my lord. Any individual could have participated, and the tender was finally granted.
Were you party in the writ petition? PIL?
I was, my lord. Unfortunately, I do not want to cut a sorry figure before this honorable court, being a crying baby, for the simple reason my chartered accountant let me down when my company was struck up.
Did you contest the matter?
One small submission, my lord. I did, my lord. I did,
We
my
have,
lord.
we just want to know whether did you put contest the matter? You were
Please, my lord, I did. I did, my lord. I
you
did.
find
On the
you find
first
the statement
occasion,
of
when,
objection. You file the statement
please,
of
my lord, I
objection.
have, my lord.
Yes.
Yes, my lord, I had, my lord.
No.
Unfortunately, on that day, a junior advocate had appeared before this honorable court, and he was not able to drive out the right facts before this court, my lord. For reasons best known, my lord.
Mr. Sanjay,
Please, my lord.
you are asking
Please, my
for
lord.
the review petitions limited to expunction of certain observation in para 2. It's not for review of the
Please, my
order,
lord.
it's only for expunging certain observation. What is that observation that you want the
Please, my
expunging
lord.
of? You don't find any, it's only a
Please,
recording of the statement.
please,
If
my
they
lord.
issued a notice and they have terminated your MOU, that's
My
all.
lord, please,
Whether
not
valid-
my MOU was never terminated, my lord. It was stated before this honorable court, it is on record, which says that my MOU was terminated. I have produced documents before this honorable court, which very, very clearly shows that my MOU was not terminated, my lord.
Whether we
Let
have
the
held
records
it,
be called for.
whether we have held it that your memorandum was terminated. Whether the court has held
Please,
it.
my lord. Please, my lord. I would like to draw my lord's kind attention to paragraph page 15. My lord, it is in page 19, my lord.
What do you want to show?
My
We
lord,
want to know whether
paragraph 2.
we want to
Paragraph 2, my lord.
You people don't understand. You are appearing virtually and you're not listening to the court properly.
I apologize, my lord.
We want to know, you want that expansion of some portion in paragraph 2. Your grievances
Yes, my
with
lord.
respect to the observation made in paragraph 2 regarding the that your memorandum of understanding was cancelled. Now, this was the stand of the respondent. The court has not held anything. The court has only recorded the whatever has been said in the statement of objections on 4/1/2022.
Please, my
Court
lord.
has not given
My lord is
anything on that. How you are
my
aggrieved
lord
by
is
that?
right.
How you are
I am
aggrieved?
aggrieved by the fact, my humble submission before this court is that none of the objections prepared by the state was filed before this honorable court, which would have brought to the notice the real truth in this matter, my lord. I am aggrieved by it is not that I'm making some allegation, baseless allegation, my lord. I have produced those objections along with my review petition, my lord. It is there
Court has
at
taken note of the
page
statement of objection 4/1/2022. You are saying that it has not been filed.
It has not been filed, my lord. If it had been filed, then the order
Where from the
which
court
was
has seen
passed by
this?
this on.
Where from the court has seen it if it was not on record? Court has noted respondent state has filed a statement of objection on 4/1/2022, stating that memorandum of understanding was entered with fourth respondent since fourth respondent has been declared a successful bidder in the tender process. Now, where
My
from this
lord
has
is right.
come?
Fortunately for me, my lord, I have been able to obtain these copies by way of RTI, which should have been placed before this court in the first place, my lord. I do not know the reasons.
The RTI is not above the whatever has been said in the court order. We cannot
That is the
disbelieve
case, my
this.
lord. My humble submission.
We
Definitely
don't
not,
know
I'm
what is
not
the
hinting at that, my
confusion.
lord.
Mr.
I have been a
Sanjay,
lady entrepreneur who has been.
Mr.
Yes, my
Sanjay,
lord.
it's a statement which is made by a council which has been recorded. Can you ask for expansion of a statement made by a council?
No, he says that was
It
not
may
on
be right,
record.
it may
I'm
be
not.
wrong. That's a different issue. It may, even assuming it is wrong, there's no order which has been passed. The petition itself has been disposed of. There's no order passed against you.
Nothing.
My respectful submission is, if my humble submission, my lord, if those objections which were prepared by the state had been filed, the application would, the writ petition would have been dismissed with exemplary cause, my lord. Now I have been made to suffer where with the remarks which has been passed by this honorable court, I lose the right to participate in the tender again, my lord. I'm trying
Court has not made any
blacklist me, my
remarks.
lord.
That is not done in the order. Mr.
That
Sanjay.
is not
You're presuming things here.
I seek for a small accommodation
What is
that the
the
matter be
confusion?
posted for Tuesday. I will appear in person before this
All right,
honorable
all
court,
right.
my lord.
We have heard you, yes.
May I make two statements? Statement of objections was filed on 4/1/2022 based on the documents which were there as on the date of cancellation of the MOU. Show cause notice also was produced, and it is sworn to by the officer. So what the counsel for the petitioner now says, review petitioner, that they had given a draft, yes, paraphrase remarks that has not been filed before this honorable court. That it is the prerogative of the officer, litigation conducting officer, to state the real facts before your lordships. The draft shared by my learned friend's client should not have been filed. I cannot file that. He had shared one draft through some officer with whom he had led the relationship. That I cannot file, no. It is still lying in the file. I should protect the interest of the state, not my learned friend.
Nothing in this review.
I like to submit my lord.
I don't know how it is.
Now, whether this statement of objection was filed on 4th or not?
Yes, my lord. I have filed it. It is sworn to by the litigation conducting officer. I have also enclosed the document.
How he says that from RTI he has obtained that that has
There
not.
was a paraphrase remarks given by friend of my learned friend that we have not adopted. That is his case. But it is. Who is he to say what I should file?
I seek for a small accommodation, my lords. Let the matter be adjourned for Tuesday. I'll be present before this honorable court. I'll need 5 minutes, my lord. It is wrong on my part to appear virtually, my lord. Let the matter be posted for Tuesday, my lord. It's my humble submission.
What for?
My
We are
respectful
satisfied.
submission, my
We are
lord.
satisfied that there is nothing, no error apparent on the face of the record.
I will demonstrate before my lords where it is not an error, my lord. It's a blunder. If the state can go to this extent and make a submission, my lord, I need to submit proper submission before this honorable court. Let the matter be posted for Tuesday, my lord. I do not want to lose this opportunity. This is the last opportunity I have, my lord, and my right to life would be violated, my lord. I'm a lady entrepreneur, my lord. I'm one of a kind. One last opportunity may be given, my lords.
Not understanding. Counsel for the review petitioner seeks for and is granted a week's time to produce certain documents and address his arguments. Mr. Sanjay, you are doing it at your risk.
Much obliged, my lord. Please, my lord. I understand, my lord. Much obliged.
Tomorrow.
Mr. Sanjay, can you come tomorrow and produce the documents?
I am not in town, my lord. That is the reason. Monday is my dad's ceremony. That's the reason I am seeking time till Tuesday morning, my lord. Date can be fixed. Anything goes wrong, I can be held responsible, my lord.
Thereafter, bench is not available, so we
My
cannot.
lords?
We cannot adjourn. Give the file. After tomorrow, bench is not available. If you want accommodation, we can
In
give
that
you.
case, I will make my submissions. Please, my lord. I'll be available tomorrow, my lord.
Tomorrow.
Is granted a day's time.
Much obliged. Much obliged.
Number 9. Sujat Bhuya. 41 Milord. I appear for the petitioner, my lord. Lord, I seek for a week's adjournment. I need to file an amendment application, my lord. But the dispute is regarding survey number 81 of Matchwaldi village.
Amendment application.
My lord, so the dispute is regarding survey number 81 of Matchwaldi village, my lord. The state government had allotted 78 acres of survey number 81 by impugned order were impugned. And in July of 2021, respondent number 41 filed an impugning application saying that 3 acres of survey number 81, apart from the 78 acres, have been allotted to them. So we need to impugn that order as well, my lord.
Counsel for the petitioner seeks for and is granted 2 weeks' time. Filing amendment application.
Yes, Mark. Number 10, Sukumar KV.
I appear on behalf of the counsel for the petitioner, my lords. I seek for a short accommodation. My senior is unwell, my lords.
Again, on the request made on behalf of counsel for the petitioner, just give a date after 3 weeks.
Lord, short question, Lord, this is covered by the judgment of this honorable court.
5-4. Number 11, in BS.
The multi-state scam related in the agri-gold company was defrauded the depositors. On the last occasion, state made a submission that they have taken steps to transfer all these kind of cases to a different state before the Supreme Court. The government has to answer it.
Lords, I have instructions, I verified. No matter is pending before the Supreme Court.
My lords, if my lords have a look at the order dated 15/11/2021.
Presently,
Even today,
no matter is pending
additional
before
government advocate appearing for the respondent submits that petition is filed before the Honorable Appeals Court and same is yet to be listed for consideration of appropriate orders. 15/11/2021.
15/11.
15/11/2021.
Orders are there.
Please, Lords. On that day, that was the instructions given to me over phone. I got it verified. We checked the matter. Lords, AC Ramnagar, clarification was sought. And after that, Lords, on verification, it's found matters were found pending only in Udupi court and no petition was made before the Apex court. Lords, that submission, Lords,
the submission has been made, Rajeshwar. 24/8/21, 27/9/21. 15/11.
That was the instructions given to me. Now we got it verified. I placed it on
Proceedings have
record.
got derailed for 6 months. For the submission.
Even today, learned additional government advocate appearing for respondent submit that a petition is filed before Apex Court and the same is yet to be listed for consideration of appropriate orders and therefore he prays for adjournment to enable him to seek status of the pending matter before Apex Court.
I'll keep the concerned official who gave that instructions to me. But this is the fact, my lords, which I would place before my lords. I can only make submission based on what instructions my lords are getting.
Who had given you instruction that petition has been filed before Apex Court?
That is from the Ramnagar, my lords. Office of the Ramnagar, Assistant Commissioner's office.
Let him appear.
Please.
From 6/7/2021 on 4 occasions submitted.
On 4 occasions, learned AGA has informed the court and sought adjournment on the ground that a petition has been filed in apex court and matter is under consideration before the apex court. Today, full stop, today when the case is taken up, Mr. Rajshekhar Leonard AGA, on the basis of instruction, submit that no petition is pending before the apex court as no case has been filed. It is submitted by him that the office of the Assistant Commissioner Ramnagar had given the instructions to him earlier regarding the pendency of the matter in the apex court. It was because of the instructions given by the office of the Assistant Commissioner Ramnagar that the matter was adjourned 4 times. Let the Assistant Commissioner Ramnagar appear before the court to explain his conduct. Please. Give a date.
10th March.
I beg to appear for the second respondent. I am praying for a very short accommodation because the learned senior counsel appearing for the respondent in this matter is not keeping well.
This is a very clear-cut case. In fact, time and again, they have been seeking adjournment.
No, sir, I have filed my statement.
And,
I have filed my statement quite some time back.
Concluded. This is pertaining to a matter which was already decided. There was a matter pertaining to this.
On the last date, you were not present.
Yes, sir. That I accept. My apologies for that.
Today, he is seeking adjournment.
Date may kindly be fixed once we'll go on with the matter.
Shortly.
Please.
When a counsel is not well, should you oppose it?
Shortly.
A short accommodation is granted to the respondent.
Second respondent.
Second respondent. Give it
23-3.
I'm grateful.
Number 13. Prince Isaac.
And for the respondent number 6 in this matter, my lords, I seek for an accommodation to file statement of objections, my lords, because I have to file my version.
He had to physically come to the court for this case.
The lordships have already ordered notice and directed the state government to remove the encroachment.
Otherwise, he appears virtually most of the time. What to be done? What is to be done?
Survey is undertaken, Lord. I have instructions from the Assistant Commissioner to say it's a huge extent of land and there are too many encroachments and things. So, Lord, we need some more time, Lord, for joint survey.
We have also written letter to the revenue authorities as well as to the
Going on, Lord.
Still the survey is taking place, my lords. That's the reason.
Right.
We have to find exact what is the measurement.
What is the interim order?
Lord, to remove all encroachments, it's about to have 136 acres of a particular hospital. Government hospital has been.
You file the status report?
Lord, except the joint survey, Lord, it is ongoing, Lord, there are no development. And there is little non-cooperation, Lord, from the
For removal of encroachment, you need cooperation.
survey itself, Lord. But in order to identify the land, like
Who will
survey-
come? Who will come to you and say that please remove my house?
Like it's a pretty old property, Lord, where this hospital is located. For decades, there have been.
One of the oldest hospitals in the state.
Peace, Lord. And encroachments have happened, Lord, several decades ago. It's the problem. And they are not cooperating, Lord. Because
Lands granted by the Maharaja of Mysore is a part of this hospital. 70 acres of land.
Then better remove the hospital. Huh? If you are unable to remove the encroachment, the other alternative is remove the hospital itself.
176 acres, my lord.
What type of submission you people make? The net AGA praise for is allowed 3 weeks further time to file the status report regarding the compliance of the interim direction issued by this court regarding removal of encroachments. You appear for?
Respond number 6, my lords.
You want to file a statement of
Please,
objection?
my lords, have to file.
The counsel for respondent number 6 prays for is allowed 3 weeks time to file the statement of objection. Give it a list on such and that, and the interim order granted earlier shall continue till next date of listing.
29E. Number 14.
Much.
Mr. Subramani M. One Muniappa filed an application for stay. That I filed the application. One Muniappa filed an application for UTD in this restriction as respondent number 3. So yesterday I filed objection to that application. Matter where the respondent board has refused my request for consent to operate the industry. Against that matter, I filed the restriction.
That's in this matter.
Who is the person who has filed the impediment?
There are some civil disputes between my lessor. I am operating a lot by taking the property on rent, plot on rent from one Ramchandra agreement. There are some civil disputes between this Muniappa, who is the proposed respondent, and my lessor. That is pending before the court in a miscellaneous second appeal. And there is a stay order in my.
Then pay how pay and maintenance. The pay. अच्छा PU.
It gets designated as that because it comes before this.
The I, which is EIL and EOL, it's written.
EOL.
Yes, what do you say?
That's, we have instructions for that. The refusal is on the basis that he does not have any valid lease deed in terms of running the entire pharmaceutical industry or that particular business which the petitioner is running. In addition to it, we don't have documents to justify that.
Order is appealable.
That's,
order is appealable.
Yes, but it's an appealable remedy, but the appellate authority is not sitting. Because of that. That's the only. But there was a.
Authority is not functioning, therefore
That's a notice was issued, and that's a detailed hearing was held, which my lords will get at page 175. Annexure V, my lords. I'm sorry, my lords, it's page 176, Annexure W. It's not a case that we have not given him an opportunity, my lords. It is an issue where, if my lords may look at page 177.
Authority, there is no appellate authority as yet?
No, my lords. Last 4 years it's. But he, in his list of dates, my lords, he has mentioned that he has submitted documents 6 days after the refusal, my lords. Which annexure is that? Which is? After the refusal, after 6 days, he has come and he has submitted the documents. Now, if that is the case, my lords, we will have to verify it with the KIDBA whether if the land belongs to him.
Now, you come to page 178.
Please, my lord.
Last, the consent application is reported to be pending at regional office.
Yes, my lords.
Same shall be disposed of as per delegation of powers suitable for orange category units prescribed.
Yes, my lords. The consent application, my lords, is an annexure, the application which has been filed, my lords will get at page 31, annexure C, my lords. We had raised an issue to provide, my lords may look at page 31. In fine letters, my lords, we have mentioned that please upload valid KDBA possession copy, list of directories of the company, extract date of commissioning of the industry with supporting documents, 4 production details, copy of SSI certificate obtained from Department of Industries and Commerce. And it's only after that, my lords, may look at page 18, annexure A. The reason which we have even recorded, my lords, while we are refusing it, is that these documents have not been provided to us. Lords may come to page 18, my lords. At the middle quadrant, it starts with specific reasons. The consent application submitted by you seeking consent for operation from board under the provisions of water is not accompanied, Water Act is not accompanied with proper/adequate land documents of the landowner with clear title who has executed rental agreement for establishing, operating the said industry in the above mentioned location. In view of the said discrepancies, the consent application submitted by you seeking consent for operation is hereby refused.
Where is the impeding applicant, Mr. Bruni? You'll have to deal with him also. He is the one who is opposing your. Until your title issues are clear, how can they give you?
May I point out one page 39?
Virtually any consent will be given to encroach.
Without title, how can you get it? And the title dispute is pending, you admit it. Well,
This is a plot allotted by KID. There is a decree in my favor. After 6 years, he files a regular appeal before the district court. District court remanded the matter. Against which I filed a second appeal. There is a stay of the judgment.
But then you have to upload all these documents, whatever it is.
For that reason, kindly see whether.
Can we get into the title issues in a writ petition?
No, I'm not seeking that. I have produced the documents, only to point out. In page 39. That the document which was sought by the board, board submitted on 28th and 2020.
So if we have submitted, consider this.
That's in regard to this, that's the page 177, minutes.
Chaudhary, you want this document? He's saying he submitted it.
I
will ask him to submit it once again.
Yes, minutes. Let him submit it. Reconsider. Reconsider it, minutes. After taking concurrence from
get into all these documents.
we cannot decide the title, whether he has the title or not, we cannot decide.
If we are sitting on RFA, we could do it.
You satisfy yourself. We'll dispose of this.
Please let him reconsider. I will produce all the documents.
Not reconsider, consider afresh.
Yes, consider afresh. I may be given an opportunity, I will produce all this.
The petitioner is before this court seeking for the following relief. The grievance of the petitioner is that the application for consent filed by the petitioner has been rejected by the refusal order dated 3/8/2021 at Annexure A, which he submits could not have been passed in view of all the documents relating to the title of the property and his interest in the property had been submitted way back on 28/10/2010 as per Annexure E. With the above situation, Shri Mahesh Chaudhary, learned counsel for respondent number 1 and 2 submits that if another set of these documents are supplied, the respondent would consider the application of the petitioner afresh in accordance with law. The submission is placed on record. Thereof, the above petition is dismissed. Has also been filed. So the said counsel is not present today. The respondents are also directed to afford the opportunity of hearing to the impleading applicant, consider the documents to be furnished by the petitioner within a period of 15 days from the date of this order, and thereafter pass necessary orders within 4 weeks thereafter.
Impleading applicant otherwise present.
Mr. Ravish, please unmute yourself. Unmute body.
Mr. Ravish, unmute your mic, sir.
Yes, my lord. Serial number.
You heard the order, Mr. Ravish?
Yes, my lord. Now I audible, madam.
Mr. Ravish is also.
Yes, my lord. Serial number 14.
Yes, we have directed the KSPCB to give you a hearing and also hearing to the petitioner. You can submit your document, they will consider all the documents and pass necessary orders.
Much obliged. Much obliged.
Appearance may be noted. N.G. Ravisha, that counsel appearing for the impleading applicant, that's the one the line act is, what we read. Submit that he has filed an impleading application and he also be provided an opportunity of hearing by the respondents.
Number 15, Mr. Prakash B.S.
Thirty-one 3/2015.
31/3/2015 and rejected. Even with that, my lord, it is of no answer. 8A4 is applicable. 8A4, the criteria.
What did you do from 31/3? Before the amendment. Rejected.
By operation of law, my lord, as per the deeming fiction, by operation of law, the lease is deemed to have been extended from the date of its original grant up to a period of
It was
20 years.
rejected before that.
Please, my lord.
It was rejected before amendment.
It is true, my lord. It is true, my lord. It is not delayed, my lord. But even that be so, my lord, Rule 8A4 provides that it is automatic, my lord. The extension is automatic from the date of original grant.
As on the date on which the amendment came, 8A4 came in.
Please, my lord.
12/8/2006. It has already been rejected.
No, correct. But only thing is what the rule says is, my lord, rejection is not no consequence. Only the renewal application should have been filed in time, which has been done in this case, my lord.
You could have challenged this.
Which one, my lord? I have not
This
challenged it.
rejection on this ground alone. If that was so, you did not challenge it.
No, my lord. It was not communicated to me, my lord.
You have only produced it today.
Please, my lord.
May I make a submission? His renewal application was rejected
on 21/2/2011.
No. That is where he is mistaken.
21/2/2011 is his application, which has been rejected on 31st of March 2015.
Application, yes, Lord. Rejected prior to 12/8/2016. It is not
He is also saying.
It is not a saved application.
No,
And
no.
there is a reported judgment of.
No. It is not
It is
an
covered by
application,
this.
my lord. Our case is totally different. Kindly see, my lord, 8A4, my lord. 8A4, my lord. They will read, my lord. The period of all the lease or license of the non-specified minor mineral, except the mining lease of minerals now classified as minor minerals, granted before the date of commencement of Karnataka Minor Mineral Concession Rule Amendment Rules 2016, the validity of the leases or license are expired or about to be expired under Subroute 2 shall be extended and be deemed to have been extended with effect to the date of expiry of the period of renewal last made up to a period ending on 31st March 2020 or till the completion of the renewal period if any, or a period of 20 years from the date of grant of such lease or license, whichever is later, subject to conditions that all the terms and conditions of the lease have been complied with, and also subject to whether the renewal application for the expired lease has been made by the lessee within the time period required for filing such renewal.
All right. Now, in your case, it has been rejected.
Please wait.
Now, this order is there. Rejection order.
Rejection order is there, my lord.
Come to Subrule
So,
8, Mr.
8. Subrule 8.
Subrule 8.
Please, my lord. 8(4), my lord. Subrule 8 is applicable only for reclassified minor minerals.
No.
But major, I read, my lord. The provisions of this rule, notwithstanding anything contained therein, shall not apply to a quarrying lease or license or mining lease of minerals now classified as minor minerals by notification of Government of India bearing so and so, my lord.
Which
It is
renewal has been
applicable.
rejected.
In our case, my lord, it is a minor, non-specified mineral from the beginning, from the date of grant.
No, he's not reading it properly, Maharaj. Subrule 8 is clear.
It's a good interpretation, Mr. Prakash. but-
No.
No,
The
may not.
provisions of this rule, notwithstanding anything contained therein, shall not apply to quarrying lease or license or mining lease of minerals now classified
There are 3 categories.
as major minerals by notification of Government of India bearing number so and so dated 12/2/2015, granted before the commencement of the Karnataka Amendment Rules for which renewal application has been rejected or it has been determined or lapsed. This applies to the mineral.
Whichever is there in that list,
Please,
it has been granted earlier, and if it has been rejected, it won't.
In our case, it is not a reclassified mineral mineral.
We'll clarify.
A1, it is a non-specified mineral. So therefore, A4 is applicable mineral.
It's probably a good argument requiring clarification.
This is my honest understanding, mineral. Sincere understanding is this, because it says
May not be correct, Mr.
non-specified minor mineral, except there also they use the word mineral, except the mining lease of mineral now classified as a minor mineral, which was earlier a major mineral. Now classified as minor mineral.
That is not.
In the instant case,
You're putting in that words was a major mineral.
here itself is same mineral, except the mining lease of the minerals now classified as minor mineral. The rule says mineral. Subrule 4 of Rule 8. Subrule 4 of Rule 8 may kindly be seen.
Yes, Mr. Prakash, we'll deal with
There
it.
it says the period of all lease or license of the non-specified mineral minerals, except the mining leases of minerals now classified as minerals granted before the date of commencement of Karnataka Mineral Mineral.
The petitioner is before this court seeking for the following relief. The grievance of the petitioner is that the petitioner had been granted a quarrying lease in respect of 2.20 acres of land situated in survey number 47 of Naduvanalli village, Chikballapur Taluk, Chikballapur district for a period of 5 years with effect from 30/5/2006. For the purpose of quarrying building stone, which is a non-specified minor mineral as classified under the provisions of the Karnataka Minor Mineral Concession Rules 1994. The petitioner made an application for renewal of the lease on 21/2/2011 in terms of Rule 21(2) of the KMMC Rules 1994, which renewal application came to be rejected on 31/3/2015. The petition of Shri Prakash Leonard, counsel for the petitioner, is that, irrespective of the rejection of the renewal application on 31/3/2015, the petitioner was entitled for renewal of the foreign lease on account of the deeming fiction under Section 8A and Rule 8A4 of the Karnataka Minor Mineral Concession Rules 1994 as amended in the year 2016. He submits that in view of the said deeming fiction of the extension of the lease, which has expired or is about to expire, the petitioner's lease, irrespective of the rejection, is also deemed to have been extended. Sri S.S. Mahindra, learned AGA, would however submit that on the application of the petitioner being rejected, the same would get covered under Rule 8(8), since the said rule makes it clear that any rejection of an application, that in the event of a rejection of an application for extension, the same would not get covered under Rule 8A4, since Rule 8(8) is a non-obstante rule, which makes Rule 8(4) inapplicable to such a rejected application. In rejoinder, Sri Prakash Leonard, counsel for the petitioner, would submit that the said Rule 8(8) relied upon by the learned AGA is applicable only to minerals which have been reclassified in the year 2015. In that, if the mineral had been a major mineral and classified as a minor mineral, while notification issued by the Government of India bearing SO 423 (E) dated 10/2/2015, Rule 8(8) would come into operation if the mineral for which a lease had been granted prior to the coming into force of the amendment was a minor mineral. The provisions of Sub-Rule 8 of Rule 8 would not be applicable. Third, Sri Prakash Leonard, counsel for the petitioner, Sri S.S. Mahindra, learned AG. The short question which would arise for consideration is whether the Sub-Rule 8 of Rule 8 is applicable only to minerals which have been reclassified from major mineral to minor mineral, while notification issued by the Government of India bearing SO 423E dated 10/2/2015, or would it apply to all applications which have been rejected prior to coming into force of the amendment to the KMMC Rules 1994 in the year 2016, with effect from 12/8/2016.
Rule 8 contemplates three categories, that is quarrying lease or license.
We'll deal with it. Sub-Rule 8 of Rule 8 reads as under. The title of the said rule indicates that the said rule starts with a non-obstante clause. Thereby, the said rule would be said sub-rule would be applicable irrespective of the other sub-rules prior to it. The sub-rule 8 of Rule 8 indicates that this, in the event of a renewal being rejected or a lease being determined or lapsed, the earlier provisions would not be applicable as regards minor minerals as regards minerals which have been classified as minor minerals, while Government of India notification bearing SO 423 dated 10/2/2015. A reading of the said provision does not indicate or give rise to a presumption of a reclassification of minerals from major minerals to minor minerals, but only indicates the minor minerals classified on 10/2/2015 to be a reference point for the application of the said sub-rule 8 of Rule 8, in that so long as the minor mineral is found mentioned in the notification dated 10/2/2015, if the application had been rejected prior to coming into force of the amendment to the KMMC rules in the year 2016, or if the said lease has been determined by an action on part of the authorities, or in the event of the lease having lapsed without a renewal being granted, then the earlier provisions of sub-rule 8 would not be applicable. Applying in view of the above, in the present case, the application filed by the petitioner on 21/2/2011 having been rejected on 31/3/2015, as on the date on which the amendment came into force, it is clear that the said application stood rejected and was not in force. Once the application has stood rejected, the conditions prescribed under sub-rule 8 of Rule 8, which is a non-obstantive provision, would kick in, making the petitioner disentitled for any consideration in terms of sub-rule 4 of Rule 8. Thus, we are unable to accept the submissions made by Sri Prakash, learned counsel for the petitioner. We answer the point raised above by holding that the provisions of sub-rule 8 of Rule 8 would be applicable to all minerals which are classified as such in SO 423E dated 10/2/2015, and not to the minerals reclassified on that date.
Including quarrying lease and license. Including quarrying lease.
My lord, at the cost of reputation, we make one submission. Yes. Yes, though it starts with a non-obstructive class, my lord, he said shall not apply to a quarrying lease or license or mining lease of mineral now classified as minor minerals, my lord. Now
That's why we have explained it.
So earlier, what was there? Rule 8, A4 is applicable for the reason it is a minor mineral from the beginning, my lord, non-specific minor mineral. It is not reclassified. Here it says
That's why we
shall not apply.
That will make it very restricted, Mr. Prakash. That is not the purport and intent.
Because the law is not ambiguous here, my lord. The rule is very clear. The provisions of this rule, notwithstanding anything contained therein, my lord, shall not apply, it says, my lord. It doesn't say shall apply, my lord. Shall not apply.
Number 15.
Yes, my lords, I appeal for the appellants. Lord, seeks for a week's accommodation, my lords.
Corresponding.
I appeal for the
Adjourn on the request of counsel for the petition. Give a date.
33. Number 17. KV Narasimhan.
Appellants in the matter, my lord. They have complied with all the objections, my lord. With your lordship's kind permission, the matter could be taken up after 2 weeks, my lord. There is some inconvenience.
You are respondent in the writ petition. Were you respondent in writ petition? Petitioners.
Petitioner.
Adjourn on the request of counsel for the appellant.
33. Number 18. Vina DM.
I appeal for
regarding, my lord, license, crusher license pharmacy granted to the petitioner. My lord, despite compliance all the conditions, my lord, the statute, use was granted, my lord, by the licensing authority. Thereafter, my lord, Karnataka State Pollution Control Board also granted consent for establishment. Thereafter, a resolution was passed, my lord. So, let me kindly look at the resolution at page number 26, my lord, 11.
The last date of hearing, I was directed to take instruction from EC with regard to 95.9. Whether your Lordship kindly recollect, earlier on an earlier occasion, the same petitioner has filed an petition, writ petition, seeking the very same directions. Thereafter, he sought for withdrawal of the same. He was permitted to withdraw the same with the liberty to furnish all the particulars with reference to his filing of application in respect of 95.9. Thereafter, the present application came to be filed. On the last occasion, Lord, your Lordship was pleased to direct whether he has filed, take instruction with regard to whether he has filed an application of 95.9. I have filed a memo dated 15 February 2022, enclosing the letter of the DC, learned DC at annexure R1. I have sought for 3 instructions from the DC. Last may I kindly go to page number 4 of the annex of the memo. Page number 4 is the annexure R1. And, in which the information, see the left-hand side column are the queries asked to the DC. When the petitioner made an application seeking conversion of so and so, the answer is after due examination of e-office and conversion portal, no such application has been received in the office seeking deemed conversion under section 95.9, etc. 2. Whether the aforesaid conversion fee has been paid in respect of the application under sub-rule 9 of section 95 of Karnataka Land Revenue Act. Whereas no such application has been received, question of generating challan to pay conversion fee does not arise. 3. Whether the deemed conversion has been granted to the petitioner, if not, assign reasons with the document as to why the deemed conversion has not been granted. As there was no receipt of such application, granting of conversion order does not arise is the answer given by the DC. Your Lordship may kindly see, the petitioner has produced a document stated to be that he has made good the conversion fine. Your Lordship may go to Annexure C, page number 14. This is the challan produced. They have not produced any application for having made to the DC. Annexure C, page number 14. Page number 14 of the writ petition. Now, this is the challan in which he makes a payment to Department of Survey and Settlement and Land Records. So, Lordship may kindly appreciate in the third column. This has nothing to do with the conversion. And I have produced along with the memo a sample of the challan raised in respect of 1999. It has to be made to the Revenue Secretariat along with my memo, page number 5, Lord. In order to show the difference, it is in respect of one case Mamata. Now the petitioner is contending that he made an application, he made good the challan. It is not properly made, Lord. That is all my submission. And so far as this grant of crusher license is concerned, that has been rejected by issuing form number D. That also I have produced at annexure R3. Translated form is.
Or whether it is order is revisable?
It is appealable order.
Appealable.
Appealable order under section 15.
It is 2002.
All right.
22.
22. Yes.
Yes, sir. Well, kindly peruse that the resolution of the authority. Lord, I'll come to that. I am aware of that, but this all done, my Lord, after the filing of petition. Lordship took a serious view on the last occasion. Now they came to pass an order saying that it is rejected. I look at the resolution. I'll take only 2 minutes. Okay. Page number 26. This is a translated version. Page number, subject number 4. This is the resolution of the licensing authority.
Yes.
The license is required to be given to the stone crusher unit sought to be established by Jyoti Prakash Shetty. The said license is a patta land. Applicant has paid ₹33,000 towards conversion fee for conversion of the said land. In meeting held on 15/6/2019, it was decided that license would be granted after securing report from the Environment Department with regard to the compliance of the environment rules. Accordingly, Member Secretary informed that the officials of the Environment Department have reported that on 1/7/19 that on-spot inspection conducted on 26/19 is found that the owner of the crusher has constructed a pond to store the polluted water generated out of the crusher. The Environment Officer addressing the meeting submitted that applicant already obtained the consent for operation on CO2 and hence the base of CO2 Form 6 is pending. The Deputy Commissioner addressing the meeting opined that it is mandated to obtain the opinion of Forest Department, irrespective of the fact that whether the land is government or patta land. Form C could be granted in accordance with the rules after securing the Forest Department opinion. This is the undisputed point of time. This is the resolution of the Lord. Thereafter, I obtained, my Lord, clearance from the Forest Department, annexure, my Lord, annexure E, my Lord, page number 30. Actually, forest clearance was not required, but still I have obtained it, my Lord. Annexure E, my Lord, page number 30. But this is the clearance for Forest Department. Now, only thing, my Lord, after, my Lord, after the distressed efforts, my Lord, they cannot reject now and after filing a writ petition, my Lord, they are coming out with the Form D. My Lord, after filing a writ petition, my Lord, latest on 15, my Lord, 15 to a lordship observed that, my Lord, inaction on the part of the authorities is unacceptable. Now they are, my Lord,
You have to challenge this. Better
now, my Lord,
go and file appeal.
Now they are producing. My Lord, this is covered by the judgment of lordship, my Lord. Kindly appreciate. Once the COC is granted, they cannot reject it. Licensing authority cannot reject it. COC is granted. I have produced the orders of this court, my Lord. My Lord, challan was produced. Copy application was made. My Lord, application was made for conversion. All that I have produced the copies. My Lord, kindly look at the memo I filed, my Lord. I have filed a memo. They are denying everything, my Lord. Is quite. My Lord, my memo. Deputy Commissioner while issuing an endorsement. It should be by the licensing authority.
Mr. Pujari, there are two issues.
Please.
One is you claim that conversion.
Yes.
You paid the conversion fine.
Right.
So if you go back, there has to be a demand. For a demand, there should be an application. Where is your application?
Application I produced, my Lord. Can you look at the memo, my Lord, 23 to 2022. I have produced it. 23 to 2002, I have filed a memo. It's my Lord. Yesterday I filed it. It's before your lordship now.
It's not here.
Can you look at the? I have filed, my Lord. Otherwise, it's only issue of, my Lord, deemed conversion now. It's automatic, my Lord. It's automatic under 1959. It's also tell that. Can you look at the application, my Lord? My Lord, page number 2. That is, my Lord, of course, Rule 106A. My Lord, conversion application made on 1999 to 2020.
Conversion application made on?
1999-2020. Last you got the memo, my Lord?
Memo 15.
15.
No.
Filed on 23rd.
On the 15th also made a latest application, my lord, latest, because.
No, this is 15/2 dated, filed on 23rd February.
Yes. This page number 2, my lord.
106 notice.
Yes, my lord, this is application made for conversion, my lord. Then, my lord, conversion fee was paid. I have produced annexes C, my lord. Of course, the mining department has received the conversion fee. Government has issued the conversion fee, my lord. As the instruction of the mining department, I paid it. Where I have paid, what is, my lord, it's a technical issue. Then, my lord, say for that I have filed another application under 95(2), we are required to file. Another application was filed, my lord, for conversion.
Pujari, that has been filed on 22nd February.
That is, my lord, because they may raise the objection that, my lord, saying that this application.
This is after you filing the petition. How can this be?
No, now they are rejecting my application. Conversion, my lord. Kindly look at the form D issued by them.
No, you please answer these two questions.
Please.
One is you are saying this is the application. This is whether this is the correct format is a different issue. Where the demand raised for payment of conversion fine.
That is Annexure C, my lord. Annexure C, the
Annexure
C2.
Page number 14.
That is your payment challan.
Yes, sir.
Where the demand.
But demand, when I have issued the amount, my lord.
No, that is made to the survey and settlement department.
You are now, my lord. You are now, my lord. So far as 95(9) is concerned, my lord, whenever I make an application, only thing is, I have to make an application, I have to pay the challan. Then it's automatic. Now I have made the application also.
Now
my
you
lord.
filed it, Mr. Pujari. We are not concerned with. Your rejection was prior to your application.
Rejection is after filing of the writ petition, my lord. Not on the ground that, my lord. Kindly look at. They are citing several grounds.
You are not listening to understand. You are listening to respond. Your application has been rejected as per what Mr. Mahendra has submitted on 10/2/2022.
That is after filing of the petition.
Your application now that you are saying is for conversion is
That is, my
22nd
lord,
February.
earlier application file. Resolution was produced before, but I
That
said
is not a resolution by the, that's about the committee which says that you have submitted this. That's all. There seems to be something seriously wrong here.
My lord, who has rejected the application? Not the licensing authority. Licensing authority has to reject the application, my lord. Annexure Ds, they are producing now. My lord, it is not by the licensing authority. They have to reject the application.
There is a reply by the Deputy Commissioner saying that your application is not there.
Deputy Commissioner is not the authority, my lord. Kindly appreciate this. Under 3(2), Rule 3(2) or 4.
To whom do you apply for conversion, Mr. Pujari?
Conversion, my lord, under 95(2) Act apply with Deputy Commissioner. Conversion is one aspect, my lord. Now they are rejecting they could not, they are saying that, well, they will not grant the form.
Without a deemed conversion, can you apply, can your sanction for a quarry license be granted? What is the argument? We are not able to understand the argument, Mr. Pujari. We are asking you so many times, but you are.
No, kindly look at the reason cited by them, my lord.
We will come to that later. If the first step that you have to take to get into the door is your conversion.
Deemed
do you have it?
But in fact, under 102, 106, my lord.
That is why you have cleverly worded your reliefs also. Direction commanding grant of so and so. They're considering that there's a deemed conversion.
My lord,
You asked for 2 reliefs in that prayer.
I am given the impression that I am cleverly doing all these things, my lord, then I have nothing to say further. I am only submitting, my lord.
We are only saying the.
What I am submitting is.
Yeah, appreciating your intelligence.
My lord, there is a resolution by the licensing authority. It's a resolution by the licensing authority. And my lord, now.
Please produce the conversion application. The demand raised. That's simple. As simple as that. If you are not able to produce that, you are out of this matter.
Unless
if you produce it, then they'll have to consider.
Deemed conversion is done, how can you get? First step is not there. That is the problem.
My lord, now, my lord, they are not rejected on deemed conversion issue at all. They have rejected my application that I am not entitled for grant at all on other grounds. Now, Form D is issued. The Rule 3(2).
Not applied for the.
So you want a quarry, you want a crusher license without conversion.
Cannot be done.
You want to operate a crusher in a property which is not converted. Is that what you want?
Then, my lord, may I submit one thing? Now, I accept what the government is saying. Now, application is made, my money is paid. Now, the conversion is automatic. They have to reconsider it now. Because under 90 by 9 it's automatic.
Money paid where?
I'll pay once again if it is required. Well, what
Let
happened?
that happen. You withdraw this, let that happen and come. Because
then
you are
come.
putting the horse before the cart.
Then the memo, the endorsement issued by them should not come in my way.
This is the second time you are doing this. First time also you withdrawn it.
Yes, submitted.
Because papers have not been. Why is it happening?
All lot of irrelevant objections being raised, my lord. This is a problem for us. Kindly appreciate, my lord. Then, my lord, the endorsement issued by them should not come in my way. Let them consider it.
That is appealable order. Let him file an appeal.
No, I
First time you withdrew it saying that by inadvertence, necessary pleadings have been made, not been made, proper papers have not been presented, and you withdraw it. Now again you have come. Again the same issue.
Great problem. That is.
Yes, my lord. Yes, my lord. Submit this, my lord. My application is filed now. My lord, I'll file also. Let them reconsider it. Because it's automatic. Under 90 by 9.
You file appeal against this order and apply for the deemed conversion. We can observe this.
Not,
And dispose of the matter. You also can. Give this order.
my only endeavor is, already there is a resolution, my lord, by the very same authority regarding, my lord, clearance of my.
Then
my lord,
we will have to reject.
That whole thing is without a conversion, it could not have been done.
That's why my request is, my
Better
lord.
get it disposed of, taking the liberty to appeal that order, file appeal, and in the meantime apply for deemed conversion.
What do you want? You want to order on merits or you want to withdraw?
Yes, my lord, I will do that.
Krishna is before this court seeking for the following reliefs. After arguing for some time, Sitaram Pujari, Learned Senior Counsel, seeks permission to withdraw the above petition with liberty to
File appeal against the order.
prosecute the application for conversion filed under section 95 bracket 9 of the Karnataka Land Revenue Act, as also file an appeal. Yes, 22nd.
Filed online, my lord, online application by declaring 13.
Necessary online application in respect thereto, as also file an appeal under section 15 of the Karnataka Stone Crushers Stones Act, challenging the Form D issued by the Deputy Commissioner and Chairman, Karnataka Stone Crushers Committee, dated 10/2/2022.
Dakshina Kannada district.
Dakshina Kannada district. Is there issue about Dakshina Kannada district?
But it is not the competent authority. Without jurisdiction, that's why, my lord.
Challenge it. Because this
Then, my lord, your lordship can entertain the petition because without jurisdiction. No, appeal, my lord,
relief sought for that here, Mr. Pujari. Not, you can't make this submission. Reserving such liberty, the petition is dismissed as withdrawn.
Number 19, only the item.
Endorsement is the next EMI. Petitioner filed an application for varying leaves in the year 2014. That is on 22. So not considered even in the year 2019.
which necessitated the petitioner to file a resolution in mandamus. And this honorable court, as per annexure C in plate 40, mandamus was issued. It was not complied. Necessitated the petitioner to file a contempt petition. Before the contempt court, the government appeared and made a submission that in view of the amendment, subsequent amendment of 2015, they have sought approval of the state government, and after the approval is received, they will issue lease deed. Again, the license was issued on the condition that I will operate these varying activities only after the lease deed is issued. That was the stage where the matter was signed. Thereafter, when I pursued the matter, they issued impugned endorsement stating that the revenue department has opined that this lands falls under crop B and these lands cannot be granted for quarrying. Now, the same survey number they have given.
Alternative remedy again.
53. 53.
The next come, they have extended the lease in respect of the same number for quarrying activities.
The order is revisable.
Pardon?
Order is revisable. Impugned order.
Impugned order is the next year.
Passed by senior geologist.
Senior geologist.
Revision.
Reason is the revenue.
Revision. You have to file a revision under Rule 53.
Yes, reserving liberty to have.
Again, Shri S.S. Mahindra allowed AG access notice for respondent number 4. Petitioner is before this court seeking for the following reliefs. After addressing arguments for some time, Shri Muralidhar H.M. learned counsel for the petitioner seeks liberty to withdraw the above petition. Seeks permission to withdraw the above petition with liberty to file revision petition under Rule 53 of the KMMC rules. Reserving such liberty, the petition is dismissed as withdrawn.
Serial number 22. Same. Next 20 and 22 are same.
Same. 20 and 22 same order.
Number 21, the Sagar BB.
I appeal for the petition. I seek for a week's accommodation. I had requested a senior advocate to represent me in this matter. Today morning he informed me she is not keeping well. A week's accommodation.
Grant counsel for the petitioner seeks for and is granted 2 weeks adjournment. Relist on.
33.
Obliged.
Number 23, Dennis Butt.
Last occasion, they stated that they will produce some judgment. I have not received any copy.
There is a defect in the even memo filed by the respondent counsel. Not. We have not received the copy of the judgment there. They were to furnish the lower court records.
This was to be produced by respondent number 7.
Lord, we have Lord, I represent, my Lord, the contesting defendant, respondent. Lord, we have filed, my Lord, a memo which appears to have been, my Lord, returned, my Lord, with some office objections. We will cure those office objections.
Grant counsel for respondent number 7 seeks for and is granted 2 weeks time to produce the copies of the orders in regular first appeal and regular second appeal as directed by order dated 7/2/2022.
Twenty-one 3. 24, Altanarai.
My Lord, I appear for the petition in serial number 24. If your Lordship will kindly grant me 1 week's time, we'll advance the submissions on a date fixed by your Lordship.
Stamp duty matter on lease.
These are the matters wherein virus of Article 30 of Stamp Act has been challenged. Yesterday, one matter came up. In that case, virus was not challenged. Here, it is.
You're appealing for the petitioner is all matters, madam?
No, my lord, it's only serial number 24.1.
My lord, I appear in serial number 24.1. We had engaged Mr. Nagan and given to understand that he's traveling today. So if your lordship may kindly have the matter on another date. Mr. Nagan that previously indicated that it may take about 2 to 3 hours for his arguments.
My lord, I appear for serial number 24.
All the counsels for the petitioner seek for a short accommodation. Relist on.
Number 25, Sanket M. Hanagi.
May it please your lordships, I appear for the petitioner. Well, this is a matter pertaining to the renewal license. Well, basically, as per Annexure A, page, for the sake of convenience, I would like to request this honorable court to take the connected matter first. That is 46971 of 2017. Lord, in 46971.
Who appeared for the respondent?
I appear.
May I submit, my lord? The lease was granted by the respondent authority with an annexure number 24 for the period of 5 years, commencing from 17/5/2014.
Statement of objection.
A short question, Lord. He has not at all filed renewal application. His lease was expired lease. It attracts 88.
Lapse lease.
Lapse lease.
Give the other file.
Para 3 of my statement of objection.
Lord, my short submission before this honorable court.
You are arguing in 46971.
Yes, my lord.
Yes, my lord. Yes.
As per Annexure A, page number 24, the translation is at page number 45. I was granted a mining lease to extract the construction stone in survey number 212, bar P16, measuring 2 acres. On 18th May 2009, which was valid for the period of 5 years, that is till 17/5/2014. In the meantime, as per Annexure B, dated 16/7/2012, page 67, the Deputy Conservator of Forests makes a communication to the Deputy Director, Departments of Mines and Geology, Davangere, stating that the scheduled property is situated within the reserve forest area, and he objected for the mining activities thereunder. And as per Annexure C, page number 72, translation is at page number 74, dated 19/10/2012. Based on the communication made by the senior geologist, the Department of Mines and Geology, Davanagere, has proceeded to pass an order dated 19/10/2012, cancelling my mining lease with effect from 19/10/2012, only on the ground that the Deputy Conservator of Forest made a communication that this property is situated in the reserve forest area. Immediately thereafter, petitioner has approached the Joint Director, Departments of Mines and Geologies, presenting a review petition, that is Annexure D, page number 78. Translation is at page number 80, dated 24/10/2013, seeking for a clarification. And the Joint Director, Department of Mine and Geology, with order dated 24th October 2013, declined to review the same in view of the confusion between the Revenue Department and the Forest Department regarding the location and situation of the property as to whether it is in a revenue land or in a forest land. I approached the office of the Deputy Commissioner by preferring an appeal under Section 136(3) of the Karnataka Land Revenue Act. The Deputy Commissioner, with a order dated 8/9/2014, this is relevant now, 8/9/2014, at Annexure E, page number 84, translation is at page number 89. The Deputy Commissioner had, upon holding a detailed inquiry, that the property scheduled for mining activities, which is the subject matter of the mining lease, is situated not within the forest area, and he said specifically and recorded a finding that it is not within the reserve forest area at all. And on 19/11/2016, and as per Annexure F, page number 105, translation is at page number 107, the Office of the Deputy Conservator of Forest, with a communication dated 9th November 2016, issued NOC. Earlier, there was already a NOC. There is another NOC, fresh NOC, in respect of the scheduled property, confirming that the scheduled property is not situated within the forest area and the mining activities thereunder shall not affect the forest area at all. And thereby, my lord, the petitioner, based on the order dated 8th of September 2014 passed by the Deputy Commissioner and the NOC issued by the Deputy Conservator of Forest, made a representation to respondent number 5 seeking for restoration of the mining license. And the Annexure G is a petition wherein he sought for the restoration. Annexure G, page number 113, translation is at 150. The case of the petitioner for restoration of the lease, as per grant of the order of grant as per Annexure A, was considered by the task force and the district stand committee under the chairmanship of the Deputy Commissioner Davanagere, and under the proceedings dated 6/3/2017, kindly appreciate the date, 6/3/2017, has held that the petitioner be entitled for the continuation of the lease granted initially at Annexure A, and decided to forward the request of the petitioner for the restoration of the lease as to the respondent number 3 to 5. Thereby, on 3/7/2017, as per Annexure A, page number 139, translation is at 140. The Office of the Director, Departments of Mines and Geologies, while considering the case of the petitioner in furtherance of the decision taken by the task force, held as per communication dated 3/7/2017 that the petitioner has not submitted an application for renewal, and therefore they have rejected my application for extension of period in as much as continuation of the lease. My short submission before this honorable court is, I was granted a lease for the period of 5 years, commencing from 18/5/2009. First submission. In the meantime, it was interrupted from 16/7/2012 till the final communication which was made on 6/3/2017. It is because of the confusion between two departments I could not carry out the mining activities because my mining license itself was under suspension or was cancelled. Because of the misunderstanding or miscommunication or otherwise between two departments, I have been put to loss. Well, this is not a normal case wherein I have been allowed to carry on the mining activity. And thereafter, I could have filed an application for the renewal. This is standing on an entirely different footing wherein my period of license or lease has been interrupted by the government itself, one department, and the other department responds to it. Then they decide and they restore my license. And from the date of cancellation till the date of restoration, that period needs to be exempted. And that period, I need to be allowed to continue my mining activities by first submission. Otherwise, the basic order of the original order of grant of license will not be come into effect so long as the lease is restored. And my lease has been ordered to be restored only on 6/3/2017. And under those circumstances, my lord, that period needs to be excluded and that period needs to be allowed for me to continue my mining activities. And under the rules, my lord, the prevailing rules, kindly appreciate one submission of mine here. I would be governed by the rules prevailing then and not the subsequent rules, as my mining activity has been commenced as per the grant of the order of grant of lease dated annexure A, page number dated 18/5/2009. So, my lord, within that period, if I file an application for renewal in a continuation period after restoration, my application for renewal could be considered, and that's the secondary part. But however, there is no hurdle for the department, no obstruction for the department for me to allow to continue my mining activities for the remainder term, which I'm entitled under Annexure A. So, my lord, under such circumstances, my lord, the approach of the respondent as per Annexure K and L itself is not in accordance with law and not as per the terms of the contract and as per the terms of the lease, which confers me the right to carry out the mining activities for the period of 5 years. Under such circumstances, my lord, since it's a unique case wherein my contract itself has been already obstructed and interrupted by their own activity or the lapses, it should not be put to loss. And under such circumstances, my lord, the order passed at Annexure K and L is a premature order, as if I'm seeking for the renewal. Renewal is in a case where I complete my term. Continuation is in a case where the lease is restored. There being a difference between a renewal and a continuation, they have misinterpreted it in entirety, and they have considered my case for the renewal and rejected my case, which itself is not in accordance with law for respective submission. Under such circumstances,
what you are asking, Mr. Sanket, is you want 1 year, 5 months.
Not 1 year, 5 months, fellow. From 18/5/2009 till 16/7/2012. I was allowed to carry out. That is 3 years I have been allowed. 3 years, 2 months I was allowed.
So from 17/7 to 19/10/2004. Sorry, from
18/5.
17/5/2014. So basically, you are asking for 1 year, 7 months.
1 year, 7 months upon restoration of my mining lease for the mining activities, number one. Then the question would arise, if I make an application for renewal, to consider that application, whether that application could be considered under the prevailing rules or the rules prevailing at that point of time as per the Annexure A.
You haven't made an application for renewal at that point of time. So it's not a safe one insofar as renewal is concerned. So is it that you are restricting your claim to 1 year, 7 months, or do you want a renewal also? What is it that you are asking?
Well, my application for renewal could be considered only after I being allowed to carry out my mining activities for the remainder term.
Mahendra,
you answered the first point, but not the second point. You said that yes, in the objections that you have filed, you're not adverted to all these aspects as to what is the effect.
Those are all irrelevant for the purpose. His appeal before the Deputy Commissioner under 130, Section 133 is no relevance at all. They are not the authorities to consider his renewal application or not.
There are two aspects of it. One is the renewal of it.
Yes.
Two is he was interrupted because of a confusion between two departments, whether it's forest land, not forest land, then it became within 100 meters, not within 100 meters. That was a dispute between two departments, for which he lost 1 year, 7 months of his lease.
That if there is breach of terms and condition of contract, Lord, he has to avail other remedy. Now his lease period was expired. Initial lease was in the year 2009. It was expired in the year 2014. Now we cannot assume and restore that. At the most, he can claim damages if he is aggrieved by if there is any breach of contract on the part of the government. So far as renewal is concerned, he is not entitled for renewal because of the change in law. Even otherwise, lease deed contemplates before the expiry of the lease period, he has to make an application for renewal. Now, we cannot renew the lease deed because there is no provision. At the most, we have to grant deemed extension. For deemed extension, one of the precondition is that he has to make an application for renewal. Now, law doesn't permit to grant any relief. Under what provision he is seeking, Lord? There is no provision to consider his plea. All that he is seeking is, your last may kindly peruse prayer C. First two prayers are Fashing Annexure K and J, and prayer C is to issue a writ of mandamus directing the respondent number 3 to 5 to restore the lease deed dated so on. So 18/5/2019. Even if it is a restore, that period is expired now. That was for a period of 5 years. It was expired in the year 2014 for the remainder period of lease at annexure A in favor of the petitioner in the interest of justice.
Petition itself 2017.
Directing the respondent to receive the application of the petitioner herein for renewal to seek for extension. That cannot be done.
No, the question could be read, my lord. It is not that I am seeking for considering my renewal application. If I may be permitted to read my prayer at the page number 17, internal page number 22, ink page 22, I would seek for a writ of mandamus directing the respondent number 3 to 5 to receive the application of the petitioner herein for renewal to seek for extension under the Karnataka Minor Mineral Concession Rules 1994 before completion of the lease period. I would only say I'm not insisting them to consider my application today. My respectful submission being, please restore my application, restore my license, allow me to continue with the mining activity. Before the completion of my period, must be allowed to file an application for renewal. You consider it independently. You can consider it or you can reject it.
C only cannot be granted.
And in my respectful submission,
any claim as regards the losses caused to you, you'll have to go to the civil court.
well, my respectful submission is that, my lord, when the license has been issued by the statutory authority and I have been allowed to carry out the mining activity, the breach is second, my lord, insofar as the damages is second, which I can have only the remedy before the civil court. But insofar as my interest to carry out the mining activities, my right to carry out the mining activities has been interrupted for no fault of mine. Under those circumstances, my lord.
Again, you are asking for specific performance by way of a declaration, Mr. Henry. That
No,
again you will have to
no.
prove.
It
We
is not so,
cannot.
sir. I would clarify, my lord, how it is not so. Firstly, that they themselves admit the lapses upon the inquiry. And now my learned brother has made a submission on behalf of the government that they are not bound by the determination or adjudication by the deputy commissioner that it is not a reserved land. If so, they could have taken it in a different way. It is not their contention in the statement of objections. Kindly appreciate this fact. It is their objection that I have not filed a renewal application. It is not their contention that the DC has no authority to adjudicate this fact. And my lord, calculatively, they are making an attempt to see to it that the mining lease should not be allowed to continue in my favor. And there are some vested interests which I may be submitting out of records, and for which reason I've been deprived of for no fault of mine. My lord, at least for the remaining period, whether I would be entitled for the renewal or not, it is too early for us to say. And it is too early for us to determine as well, unless I make an application for renewal before the expiry of the period. But so long as that period is concerned, which is remainder period in my respective submission, I may be kindly allowed, in view of the investments I have already made and my right unnecessarily, without my fault, being interrupted, obstructed, and is being restricted, my lord. 19(1)(g).
It's a contractual matter, Mr. Chengi.
My lord, statutory contract.
May I make one more submission? Even assuming that Lord DC held that it's not a forest land. The order was dated 8/9/2014. Revision was rejected way back on 24/10/2013. This was not brought to the notice of the authorities under the Act. He kept quiet and files this petition in the year 2017 after lapse of 3 years.
I'm sorry, my lord. Let the facts be very clear. The NOC was issued.
Revision was rejected. It could have sought for.
My lord, may I clarify only one aspect here, my lord. The NOC was issued to me on 19/11/2016 itself. Immediately, I made a representation within 2 months when it was communicated to me. Within 2 months, in the sense on 2/2/2007, as per Annexure G, I made a representation. There has been no lapse from my end, and I'm losing 1 year, 10 months, 18 days. It is not 1 year, 6 months or 2 months, my lord. 1 year, 10 months, and around 18 days I'm losing.
Is before this court seeking for the following reliefs. The grievance of the petitioner in the present matter is that though the petitioner had been granted a lease by the respondent authorities to carry out mining activity for extraction of construction stone in survey number 212/P16, measuring an extent of 2 acres, situated at Saturu village, Rafnalli Taluk of Davangere district, while mining lease dated 18th May 2009. The said activities of the petitioner came to be interrupted and interfered with, while communication dated 16/7/2015, addressed by the Deputy Conservator of Forest to the Deputy Director, Department of Mines and Geology, claiming the land subject matter of lease to be forest land. In pursuance of which, the Senior Geologist, Department of Mines and Geology, while his order dated 19/10/2012, cancelled the mining lease issued to the petitioner on 18/5/2009. Sri Sanket N.V., learned counsel for the petitioner, would contend that subsequent thereto there are various proceedings which occurred, wherein it has been now held that the land is not forest land and could have been, is not forest land.
On that basis, he submits that there was unlawful interruption in the mining activities of the petitioner by the senior geologist, Department of Mines and Geology, on the basis of the letter of the Deputy Conservator of Forest, and as such, the lease period for which the petitioner was not able to carry out quarrying activities be extended, and also the petitioner be permitted to file an application for renewal of the lease in terms of the KMMC rules 1994 as then existent. Sri S.S. Mahindra learned AGA, on the other hand, would submit that there is nothing unlawful in the interruption of the lease when the Forest Department had written a letter to the senior geologist that the land subject matter of the lease was a forest land. The senior geologist had no option but to stop the quarrying activities and cancel the lease. As regards the relief sought for filing of an application in terms of the law then prevalent, that is prior to the amendment in the year 2016, he submits that such an action cannot be permitted by this court. So no retrospective application could be considered by the authorities, received or considered by the authorities. Third, Sri Sanket Enigi, learned counsel for the petitioner, Sri S.S. Mahindra, learned AGA for the respondents. The short question that arises here is as to whether the reliefs which have been sought for by the petitioner can be granted in a proceedings under Article 226 of the Constitution of India. As referred to supra, there is a quarrying lease executed in the year 2009. The contention of the petitioner is that on 19/10/2012, the same was unlawfully interfered with by the senior geologist, Department of Mines and Geology, Davangere region, Davangere, and the cancellation of the lease is improper, depriving the petitioner of about 1 year, 10 months of the remainder of the lease, which has resulted in losses being caused to the petitioner. Correct. It is a matter of fact and record that from the year 2016, that in the year 2016, extensive amendments which have occurred to the KMMC rules, which require any new lease to be by way of auction. Correct. In these changed circumstances, when the petitioner himself has not made an application for renewal prior to the expiry of the lease in terms of the contract, that is 6 months prior to the expiry of the lease, which expired on 17/5/2014.
3 months.
3 months prior to, which expired on 17/5/2014. We are of the considered opinion that these issues, which are the contention of the petitioner is also that the petitioner has suffered various losses on account of the interruption in the lease, and there's huge investment which has been made by the petitioner. We are of the considered opinion that these issues cannot be gone into in a proceedings under Article 226 in order to determine the extent of losses or otherwise, or whether the action taken by the authorities is proper or not, which requires a trial on facts. The nature of relief which have been sought for in the writ petition is more in the nature of a specific performance suit, which would not be capable of being considered in a proceedings under Article 226 of the Constitution of India. In view thereof, we find no merit in the present writ petition, or reserving the liberty to the petitioner to approach the civil court
for necessary relief if so advised. The writ petition stands dismissed.
There are two matters, my lord, connected matter also on the same footing.
What is any particular change in that matter? Same person or?
There is no change, my lord.
What is that about, Mr. NG?
Except the date of grant of lease and license. That is in the first case, it is 18/5. It is 9/3/2009.
Second one is survey number 212P16. 9/3/2009.
9/3/2009 is the
Conservator
date
Forest letter dated
Annexure A.
16/7/2012 and same. The other dates are the same.
Another one submission may kindly be recorded, my lord, which would be beneficial at least in the order if it is found, that the NOC has been issued to me on 19/11/2016 and
We won't get into those things.
Grateful.
For 26, Madam Soli.
Appear for the petitioner's counsel. The matter relates to validity of Rule 410 of Karnataka Prevention of Illegal Mining, Transportation, Storage of Mineral Rules 2011, as it is contrary to the Central Act and rules.
It requires hearing.
Certainly, how long will it take?
If my learned friend is ready, we can. I will not take much time.
That the Advocate General would be addressing arguments in this matter. He seeks for a short accommodation. Released after.
Short date could be given, but last time also matter was adjourned on that ground.
It is because of paucity of time, Lord.
He is otherwise busy, Mr. Arnoldi.
Paucity should be to the court, not.
31/3.
Lord, can it be some other earlier date? Nearly 1.5 months.
First week.
Some earlier date can it be done?
31/3.
24/3.
Right.
Number 27.
Activity appellant's counsel in 27.1. Matter pertains to the constitutional validity of the Karnataka on-demand taxi aggregator rules.
It will take some time, Mr. Raghavan.
Please, of course, it will take some time.
Shanti Bhushan?
I appear for the fourth respondent, my lord, Mr. Shanti Bhushan. ASG is not appearing in the matter.
You are appearing, Mr. Pillai?
Yes, my lord.
But if their stance also could be known, but they have since they are impleted, but they have not yet filed.
They have not filed objections?
No.
Mr. Pillai, you have filed objections?
No, my lord.
Please complete the pleadings.
Yes, my lord.
So that they know this time.
Yes, my lord.
Respondent number 7, my lords, I have no objections to be filed. It's a formal party, my lords. Respondent number 7, National Highways Authorities of India, my lords.
Whoever wants to file could file so that then
Yes, my lords.
all the pleadings let it be on record.
Let me make one submission, my lord. In 27.1, there is a formal application, my lord, for impleading as an appellant, third appellant, my lord, IA 1 of 22, on account of internal restructuring, my lord, that could be allowed, my lord.
Internal restructuring. Name of the company.
My lord, one from one company, my lord, got assigned to another company. The assigning company, my lord, which has filed the application. IA 1 of 22.
The reason stated in support of IA 1 of 2022, namely restructuring of the petitioner companies. IA number 1 of 22 is allowed. The impeding applicant is brought on record as appellant number 3. Petitioner is directed to carry out necessary amendment, file an amended cause title, and furnish copies thereof to the respondent.
But restructuring of the business, not of the companies.
Shri Madan Pillai, the net counsel for the respondent union, seeks for and is granted 3 weeks' time to file a statement of objections.
Obliged, my lord.
My lord, I am the party in person seeking implement in IA 2 of 2020, my lord. In this regard, my lord, may I make one fair submission, my lord?
Yes, Mr. Dastagir, we'll consider your application when after hearing all the parties, whether you are required to be party or not.
Yes, obliged, my lord. My interest will be served only if the IA filed by the state government on IA 1 of 18, seeking permission of the court to take action against the defaulting aggregators is considered, my lord. Even otherwise, if the writ appeal is to be finally disposed also, my interest will be served, my lord.
Yes, once the state files its objections and union files its objection, will take time.
Obliged, my lord.
Meanwhile,
Good time, some date, my lord, if after not
there are some office objections on various applications. Meanwhile, all office objections to be complied with.
6th April